Hi, everybody. Today we are here to talk about the three parts of caregiving that most people do not relate one to the next. These are the medical, the financial, and the legal decisions involved in caring for yourself or being a caregiver for anybody else. And so you may hear these terms called the care ecosystem or the healthcare ecosystem or long-term care by people who work in the health and the legal care systems. So depending on who you're speaking to, you may hear those terms. So this is webinar number 2 in the series that began with the video, What You Should Know About Appointing a Power of Attorney. So in this section, we are kind of still in the before stages, the planning stages, where we're going to talk about legal definitions and responsibilities. And these include power of attorney, both medical and financial. And then I'm going to give a little bit of information about guardian and conservator so that you know what this is. This video is not going to specifically talk about that, but below in the comments section, I will put a link to another program that is in webinar form just like this. It's on my website, and it goes into great detail about guardianship and conservatorship. So before we get too far along, if we have not met, I'm Pamela D Wilson. I am a caregiving expert, advocate, and speaker. I previously served in the role of a professional fiduciary, which means I was the person named or appointed to be a medical power of attorney, financial power of attorney, court-appointed guardian and conservator, a trustee, and a personal representative of the estate, which is why I am qualified to talk about this subject with you. Let me be clear, I am not an attorney. Appointing an agent under a power of attorney is kind of like dating. It's kind of like trying to decide if this is the person that you want to be with for the rest of your life, if this is the person that you should marry. Because choosing the right power of attorney after getting married, right, after picking your life partner, is probably the next most important decision you will ever have to make. Because you have to trust this person 1,000% with everything about your health and your money, which affect your life and your quality of life, especially when you are not in a position where you're healthy enough or you feel good enough to make decisions about yourself. So in this webinar, things that we're going to cover, we're going to talk about the 4 different types of power of attorney. We're going to talk about healthcare and financial systems, look at power of attorney. We're going to look at if you agree to become an agent, what are your responsibilities and how transparent do you need to be? The answer to that is very transparent, and I'll give you some examples. So, what is power of attorney? Power of attorney falls into this category of estate planning. You might hear of estate planners or probate planners or elder law attorneys. Those are attorneys who work in this area of estate planning. And so creating your estate planning documents, again, it's a very important part of life to make sure that when you need help, you have the help from a person that you trust 1,000%. So other terms that fall into estate planning are medical power of attorney, financial power of attorney, a living will, a will, or a trust. Now, in this video, in this webinar, we're not going to be discussing wills or trusts. I'll do a simple explanation, but this is not really what we're focusing on specific to medical power of attorney, financial power of attorney, and a living will. Because here we're focusing on what happens to you during life, most importantly, so that you have the care and the access to care and the ability to pay for care that you want and that your wishes are carried through, that other people are not taking over and they are not making decisions for you. So two very common questions related to powers of attorney that a lot of people ask is, when does power of attorney begin and end? And then, what are the different types of power of attorney? So let's go into these. And if you're undecided about any of this, again, consult an elder law, a probate, or an estate planning attorney so that you can make sure that the plans you make will have the outcomes that you want. So the question, when does power of attorney end and begin? Power of attorney begins when this form, this document, is executed, except in the case of, for example, a springing power of attorney, which I'll give an example of in a minute. Now know this, any appointment of an agent in a power of attorney document can be canceled. It can be rescinded at any time by the person who created that document. And so the term for that person who created the document is called the principal, much like a principal at a high school, right? So Principal. Now, where this can get a little sticky is if your loved one has Alzheimer's or dementia and they are no longer considered capable of making decisions, they can try to fire you as a power of attorney, but do they really have the legal ability to do that? So again, that kind of goes into the discussion of guardianship and conservatorship and incapacity, but I at least wanted to bring that up in case you are currently in a situation like that and you're wondering, what do we do? So when does a power of attorney appointment end? It ends at the death of a person, because when a person dies, normally there's another document, right? It's a will or a trust who says, when I'm dead, I want this person, this personal representative, or this trustee to handle all of my financial matters according to my estate and all of these wishes that I have written in this document. And so the document that directs what happens to your estate, to your remaining belongings when you die, is called either a will or a trust. And if you have a will, you appoint a personal representative. If you have a trust, it's usually a trustee who acts for you after your death and does all these things that you said that you wanted done. So just again, we're not getting into wills and trusts here, but I want to just mention this because a lot of people are like, well, when somebody dies and I'm the power of attorney, do I keep acting? The answer is no. You cannot do anything with money. You cannot go to the bank and take out money. You cannot do any of that. That is not in your role. Okay? The agent under power of attorney has no further legal permission to act when somebody dies. Okay, so let's look at the 4 different types of powers of attorney, and I'll give examples. So there's what's called a limited power of attorney. And a limited power of attorney gives somebody else limited power to act for you in a very specific situation. For example, I served as limited power of attorney specifically to complete, for example, a health care enrollment document for a client, or to sign documents at a real estate closing. So it's for a limited purpose and a very limited amount of time. It doesn't give you control over anything. So if you think of limited power of attorney as giving somebody permission to complete a one-time project, that limited power of attorney ends as soon as that project is completed. No more. Does not exist. And then we go into what is called a general power of attorney. A general power of attorney gives somebody else the power to act for you in all aspects identified in that power of attorney document. And this is why it's really better, if you can, to have an attorney draft these documents. You're not using forms off the internet that are giving away powers that you do not want to give away. So again, general power of attorney ends at death. It also ends at a determination of incapacity if a guardian and a conservator are appointed. So you might create a general power of attorney, for example, if you want to give somebody power to act for you if you're unavailable. And this could be something as simple as you're taking a trip, you're going to Europe or somewhere and you're going to be away, and you need somebody to manage aspects of your finances or some other part of your life while you're gone. here in the United States. So you're giving somebody the power to do that. And then when you no longer travel, you kind of rescind that power. So general power of attorney, again, they're used more for short-term instead of long-term situations so that you have the flexibility to have someone to act for you. Now, this kind of takes away the situations of incapacity and people who have memory problems and dementia and they get into accidents. We're going to talk more about that in a second. This kind of leads us to what's called a springing power of attorney, which comes into this area of incapacity. So a springing power of attorney says, you know, I'm appointing this person to be my power of attorney, but only when this specific thing happens. And so in the case of memory loss or Alzheimer's or dementia, this thing that happens could be if two doctors confirm that I am mentally incapacitated and I can't make decisions, then I appoint my agent in my springing power of attorney to act for me. So in simple terms, this springing idea, right? An event happens, power of attorney goes into effect. And then we have durable power of attorney, and this is really probably the most common that people do. And this is why it's so important to be very, very careful about who you appoint. So in my professional experience, I accepted power of attorney appointments for all types of situations and purposes because it's important to know that this power of attorney becomes effective the minute this document is signed. And it continues to be effective if it's written correctly, if and when the person who wrote it, the principal, becomes incapacitated due to memory loss or another situation. Now, normally in good, durable power of attorney documents, you can put additional statements in there that say, if I become mentally incapacitated because of a car accident or Alzheimer's or dementia, I want to appoint this person, my agent, as my guardian or my conservator if that becomes necessary. You can also appoint what I call protectors. So if you're not really sure that you can trust this person who's your power of attorney, you can put a statement in that legal document that says, my agent under power of attorney will make reports, financial and medical, to this individual every month, who can provide additional oversight and who, if there is suspicion that my agent under power of attorney is not acting appropriately, who can take legal action to have my agent removed and another person appointed. Those are always good backups to put in documents because honestly, you never know what's going to happen. Because this is the main concern with a durable power of attorney, right? If you appoint somebody who is trustworthy today and becomes not trustworthy tomorrow, they have access to everything, your medical history, your medical records, your money, your financial information. And so this is where it's important to understand that power of attorney abuse, it's a legal issue. It is a prosecutable offense in a court of law. Now, the problem is that most parents would never probably choose to prosecute their children, right? And so this is what makes it all so very difficult. Abuse of power of attorney is an area where there's a lot of concern in families. And when it comes to elder abuse and financial abuse and neglect of medical care, all the research, all the records show that it is more than likely a spouse or an adult child or someone in the family who is participating in these offenses. Because it's easy, right? Who's going to check? Who's going to know? That is the dangerous part of all of these legal issues. Agents appointed as financial power of attorney can go to your bank. They can take out money. They can transfer money. Money can disappear very quickly. And honestly, if nobody's watching, if you've appointed nobody to watch over, like a protector, it can be months before anything happens, before anybody even realizes that that bank account is emptied out. So I'm telling you this. So if you are the person who's appointing somebody, you can be proactive and make sure that there are no doubts about the person who you are appointing. If you are a family member and your brother or sister was appointed and they can't manage money and they're not following through with their parents' wishes, you can go to court and have this monitored and have this questioned. And if you see abuse, I highly recommend that you do that. You may be the only person who could speak up for your parents or another person. And I'm definitely not telling you this so that you can become the bad actor, right? You can become somebody's medical or financial power of attorney and take advantage of them. That is wrong, 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 wrong. Power of attorney abuse, it also applies to the medical side, right? I have seen family members, spouses, adult children, purposely either limit care or place their loved ones in substandard care communities to save money, to preserve the estate for their inheritance. Again, my opinion, wrong, unethical, not the thing to do. And this is really the ugly part of power of attorney that nobody likes to talk about, which leads us to the next subject of you accepting the role of agent and your duties and your responsibilities. Because if you do this, you want to be so transparent. You want to act as if everything that you do, every action that you take could be on the front page of that newspaper tomorrow. And in a court of law, you could unquestionably defend every single action that you take. Because I'll tell you, it's possible. Family members, if you're appointed and your cousin or your brother or your sister doesn't like what you're doing, they can report you. They can report that your actions are irresponsible. So that's why it's so important to understand the responsibility that you are accepting and to not become a front page newspaper story. So here's things to think about. Act as if what you are doing, paying a bill, making a medical decision, if that could be on the front page of the newspaper tomorrow, how would you substantiate the choices that you made and the decisions that you made and the actions that you took? Do you really believe that you're doing the right thing? And if so, based on what? Would anyone question your intentions? Is there anything that you are doing that you wouldn't want other people to know? As power of attorney, you accept responsibility for medical care, for financial management, for the property of the person, depending on your designation. Take this responsibility very seriously because honestly, you never know what can and what will happen, and you can be shocked. So if you haven't already noticed, we're going to get into some more legal terminology. The legal profession likes to use a lot of big words and abbreviations that are so confusing for the average person. So I'm going to break down some of these into simple descriptions and terms that anybody can understand because you should be able to explain this to yourself and your loved one. So we're going to do a quick review of terms that you're likely to see in a power of attorney document. Okay, so these are going to include principal and agent, medical power of attorney, financial power of attorney, fiduciary, guardian, conservator, ward, and incapacity. And except for the term incapacity, right? These are all names for people who are involved in this legal process of power of attorney and conservatorship and guardian cases. So let's start off with the two most important words that you're going to see in that power of attorney document. And these are the principal and the agent. So I briefly described principal earlier. It's the person who is appointing somebody else, right? So I'm appointing somebody to be my power of attorney. I am the principal. The person that I appoint is the agent under power of attorney, which can also just be called the power of attorney or the agent. And let me just share a short story about this that you may have seen or heard in the news. And it's kind of a little old story because there's history to this, but if you or your parents ever remember the celebrity, his name was Peter Falk, and he played a part on a television series called Columbo, and he was a detective. And his favorite saying when he was trying to, catch people doing crimes or wrongdoing was like, just one more thing. I just have one more question for you. And it was usually like that question that solved the crime, right? Master for solving crimes. But he became older and he was diagnosed with dementia. And believe it or not, he did not have the right person to advocate for him. His daughter, Catherine, was denied visitation by her stepmother. So Peter's second wife or third wife. Anyway, the wife after the first wife, right? And this erupted into a major court battle. It was all over the newspapers. And Catherine, to the good things, right? Good part. She enacted something called the Peter Falk Law. And it's still going through legislation in a number of states. It's been passed in a lot of states. And so what the Peter Falk Law says is that if I have a relationship with a family member, that family member has a right to visit me, and no one can prevent that. No stepmother who has power of attorney or conservatorship or guardianship, no stepfather, nobody else can prevent me from visiting because I have a long-standing relationship with this person and I have a right to visit. So you can Google this, Google the Catherine Falk situation. She has a foundation. On there is information about legislation in all these states. It was a very traumatic situation at the time, but something very good with the outcome to support visitation of family members for parents with dementia and Alzheimer's and somebody who's trying to prevent that visitation. Because that does happen in families. Even people who are appointed power of attorney can say, oh, you know what? You can't visit. You can't have phone calls. I don't want you at the house. Those create all kinds of problems, right? So let's talk about medical power of attorney. And again, just what this is. So it's an agent or a person that you appoint and you trust to make medical decisions for you. But here's the definition. Just as if you are making medical decisions for yourself. They should not make decisions that you would not have made. They should not do things against your will, even if at that moment you're not able to express what you want, okay? So again, this person has access to all your medical records. They can speak to your doctors. They can make decisions about surgery, about treatments, about medication, all of that. And they can help you with other things like, applying for health insurance, medical care coordination, hiring in-home caregivers, making decisions to move to care communities, everything that's related to your daily care and your well-being and where you live, which is, again, why you must trust this person with your life. I know I sound like a broken record here, but so, so important. So let's go to the financial side. So the financial power of attorney, the agent, okay, is the person that you trust to manage all of your money and property and investments, just as if you were managing these for yourself. So they shouldn't do day trading or make crazy investments if that's something that you would never have done yourself, right? They're doing this as if they were you. And again, if it's durable, they have access to all your bank accounts, your property, they can sell things, they can move money around, they can do all of this. Again, which is why it's important to trust. And these are the areas and the reasons that elder abuse happens in families. Your children may be more interested in, unfortunately, your money than your health, or interested in your home versus their home. Family members, more than anybody outside the family, are the people who take financial and healthcare advantage of spouses, parents, and other family members. So let's now talk about the idea of a fiduciary, which could be an outside person that you appoint to be this agent under medical or power of attorney or conservator or guardian. And again, from 2007 to 2018, I acted in the role of a professional fiduciary. So a person who is appointed agent under power of attorney has a fiduciary duty, right? And so what this means is it's a relationship where one person, usually the principal, places their utmost trust and confidence and belief and reliance on another person who has a duty to act for the benefit of the principal. Okay? So Fiduciary relationships occur between agents and principals, attorneys and clients, executors of estates, administrators, heirs, trustees, between financial planners and the people that they represent. It happens in corporations, directors, officers, stockholders, creditors, guardians, wards, all these confidential advisors. These people have and accept a fiduciary responsibility. So let's kind of talk about where things start to go a little bit off track, just so you're aware. We're going to get into this more in future webinars in this series. But so as a power of attorney, I was involved in a lot of situations where my clients, God bless them, would start to write multiple checks to charities, or they were addicted to buying things on the home shopping network. And they couldn't manage their money to the degree that there was money to pay their monthly bills, right? So in many cases, this can be common with your aging parents or with loved ones or friends or family who've had lifelong challenges because they have been horrible managing their money. And if they get dementia or another cognitive impairment, it can get way worse. So this is a time when you as that family member have a duty and a responsibility to step in as a protector, right? You have to preserve their money so they can pay their bills and it can pay for their care. It can't be going to charities or lotteries or things like that. And that's not to say that you can't give them $20 to, give to a charity every month, but certainly not $2,000 or $20,000 or $200,000, right? The idea is that you're appointed so that they do not mismanage their money and suffer consequences because they've mismanaged their money or not paid their bills. Same thing on the healthcare side. As the medical person, you want to do what they would have done. So, if they have memory loss and they forget to go to the doctor appointment, you're going to get them to the doctor appointment because before memory loss, that's something that they would have done, regularly on a regular schedule. So I want to talk for a minute about what I call the bridge from power of attorney to guardian or conservator. Again, link below in the description to another webinar program on my website all about guardianship and conservatorship. But again, I just want to touch on this so that you're aware that this can happen. So the role of a power of attorney is to act in the best interest and to exercise reasonable care and due diligence and thoughtful decision-making on behalf of the person that you are appointed for to protect their health and their property and their money. Now, power of attorney, durable, is the least restrictive role. And restrictive role is a term that attorneys use and the court system uses, right? Which means that you're not taking away all the rights of the person that you act for. You're doing what they would have wanted to. In many cases, if they can still make their own decisions, you're going to say, hey, this is what I'm thinking of doing. Is that okay with you? Or would you like me to do this for you? You're just not doing things without their permission or knowledge, right? When it comes to guardianship or conservatorship, those are extremely restrictive roles, even though you still do have to act in the least restrictive manner. But those court-appointed designations give full rights and full authority to the person appointed, which again goes back to if you are appointing an agent under medical and financial power of attorney, and you have that statement in your document that says, if I ever become incapacitated, I appoint this person to become my guardian and conservator. Again, you can always put that little protector in there saying, these people have to be transparent and report things to this person. And if that person ever thinks these people are not doing a good job, that person can take steps to have them removed. Put in as many protections as you possibly can. So just to confirm, power of attorney comes before guardianship and conservatorship unless a person is incapacitated, has memory loss, can't make decisions, they never did their power of attorney documents, then it can go straight to the court process of guardian or conservator. Now, guardian and conservator can be interchangeable terms depending on the state where you live, because each state regulates this process, this court process. So in some states, the conservator might be both the guardian and the conservator. In many cases, family members can serve as both a guardian and a conservator. Professional fiduciaries, though, can serve only as one or the other, again, for a system of checks and balances. Now, before you even get to this point, you have to have a medical evaluation, thorough evaluation that shows that the person under consideration for guardianship or conservatorship, does not have the capacity to evaluate or understand information or make good decisions or evaluate information. Again, more on this, the link is down there. So let's just talk for a minute as we close out this webinar about the recognition of medical and financial power of attorney documents and agents by other systems, the other two systems that interact with healthcare, right? Which is legal and financial and medical, right? So attorneys, legal system, documents are recognized. They're pretty, I don't want to say standard, but all of the information, everything is understandable. And when you start to work with the healthcare system and banks and financial situations, that's where it can get a little sticky. So with respect to healthcare providers, doctors, healthcare systems, all of that, there's this, what I call this gray area of consent, right? Patient consent. That gets complicated if a loved one has memory loss and really doesn't understand what they're agreeing to. So, for example, your parent with dementia gets sent to the emergency room for some reason, and nobody there realizes that they have memory loss. So they're asking your parent and they're treating your parent just like anybody else who can make decisions. And your parent saying, yeah, I'll take that medication, or I want that surgery, or I want that treatment. And like, they've already had it, or it would be the worst thing for them, right? So unless those providers know that there is a medical agent under power of attorney, and this person cannot make decisions, big decisions, right? They can decide to go to the bathroom and to eat and things like that. But big decisions, they're going to default to asking that person. So you have to make it very clear that you are the agent under medical power of attorney and have those forms on file and put references everywhere saying no decisions that are important, life-threatening, life-changing are to be made unless you contact me. Okay? Now let's kind of go to the financial institution end. So banks, financial planners, brokerages, wealth managers, all that kind of stuff. They do not like attorney documents. They'll accept them, but more than likely they have their own forms that have to be signed and notarized, and sometimes signatures have to be guaranteed. You got to go through all these hoops to get them on file. So the recommendation, and I'm going to jump toward the very end here, right? As soon as you have these documents completed, put them on file everywhere you think they're ever going to be needed. Doctors' offices, hospitals, banks, financial institutions, because more than likely on the financial side, you're going to have to complete a form for every bank, for every financial planning institution, for every wealth planning institution. You have to do a ton of forms, a ton of notarized signatures, and it's better to do this before anybody has dementia or memory loss, because after the fact can be a huge problem. So that is what I wanted to cover for this webinar. So in the next webinar in this series, it's going to be number 3. We're going to talk more about legal decision-making and the responsibilities that agents have to make decisions. I thank you all so much for being here. Again, please click below to like this video, like this webinar. Follow my YouTube channel. Also, please comment, share your experiences below. I do my best to respond to every single comment. This helps these videos reach more people who are looking for hope, help, and support on these specific topics, on caregiving, on any subject related to aging, on making medical decisions. So you, through your following and liking and commenting, actually help other people in your situation. Thank you again so much. I'm Pamela D Wilson. My website is PamelaDWilson.com. You can go there for more help and support. There's over 800 videos here on my YouTube channel. Thank you. I will see you all again soon in another video.